Ladies and gentlemen, this is the court of public opinion. We are in the final stages of the Wakiaga series of videos. Now, in this video, we are going to address ourselves to the observation that some judges differ between themselves and with the criminal procedure code to the extent of the application of section 88 and section 89 of the criminal procedure code. Now, ladies and gentlemen, the criminal procedure code is exactly that. It is a criminal procedure code, and it is the one that outlines how crime should be prosecuted. There is no other procedure. I repeat that. There is no other procedure. To try to qualify any section of the criminal procedure code so that it can be convenient to some circumstances is by itself a crime against the public. It's breaking the law, actually. It doesn't matter if it happens in court, but it's no less a crime because it is applying the law in a way that is a crime by itself. So, in this video, we'll be discussing section 88 and section 89 in the context of some decisions made by some judges. Ladies and gentlemen, section 89 of the Criminal Procedure Code is a part of the Criminal Procedure Code titled Institution of Proceedings and a subtitle Making of Complaint. Now, section 88 is under a section of the Criminal Procedure Code that is titled Appointment of Public Prosecutors and the Conduct of Prosecutions. Now, section 89 is titled Complaint and Charge. In crime, the series of events are that there is a suspect, there is a crime, and a complainant in that crime, and the complainant feels that he needs to recoup his honor by having the suspect punished. The normal procedure is for us to turn up in a police station, and we hope that you will have a pound of flesh in this case if you turn up in the police station. But the reality is slightly different because you'll find that the average police station is really a scene of crime, and each policeman, we could say, is a suspect in so many ways. We have said that the greatest challenge to justice is the amount of trading that occurs in a police station. It's a big, huge market. Really, it's like a justice exchange. Now, section 89, written by the fathers of this great law, did not license a policeman or a police station to be the only people who can institute proceedings against suspects. No. The same section did not grant the office of the Director of Public Prosecutions total, absolute, and exclusive rights to institution of proceeding. It doesn't do that at all. So, in plain and common understanding of English, a suspect, a crime, a complainant, a complaint. That is the right order of events. And beyond that, the complaint to give us the charge is the first step in the judicial process. It's the first step in the judicial process. So the institution of proceedings is a very distinct process in this justice chain. It's very distinct. So we'll not belabor this point. Our aim here is to show that there are some judges who are lost between section 88 and section 89. Now, most of my discussion here is going to be based on decisions made by Justice Simpson together with Justice Sachdeva, and the decisions made by Judges Lesit, Wendo, and Emukule. Now, ladies and gentlemen, my discussion of the Wakiaga Saga series of videos, they might sound like I'm trying to casually pigeonhole this problem. No, it's not the aim. I am approaching it as objectively as I can. If it happens that the persons in question are extracted from a given cultural setup in our nation, it's too bad. It can't be helped. We don't have to be politically correct for us to discuss such grave matters as the institution of proceedings. Straight away, let us see how Justice Simpson and Justice Sachdeva understand this. So, ladies and gentlemen, Justice Simpson and Justice Sachdeva understand section 88 to be about a case that is already instituted. I share that understanding with them, that section 88 is about a case that is already instituted. It has passed the making of a complaint, there's a charge in court, and like Justice Sachdeva and Simpson say, and I quote them, in the context of section 88, however, trying, we think, must include taking a plea. Full stop. It is, we think, clear that the trail of the case cannot start before the accused person is before the court. Thus, that is section 88. Section 88, Justice Sachdeva and Simpson, they understand it to be about a case that is already instituted. It has passed the complaint, it has passed the making of a charge, and a magistrate has decided that there is enough evidence for institution of proceedings against the suspect. Now, Justice Simpson and Sachdeva continue to say, as soon as an accused person is before him in court for the purpose of pleading to a formal, duly signed charge, no magistrate can properly be described as trying that case. I want to repeat that. As soon as an accused person is before him in court for the purpose of pleading to a formal, duly signed charge, no magistrate can properly be described as trying that case. I think these judges are being nice. They should just be saying that the text of section 88 is plain and in the common understanding of English, let us just follow that procedure. They are highlighting that trying means that there is a suspect in court and the case has been instituted. Section 88 of the Criminal Procedure Code is about a case that is already instituted, and the role of parties is in court. The suspect and the complainant are in court. Institution of a case does not require the presence of the suspect, does it? So for that reason, the whole of section 88, the suspect is already in court. You cannot have the suspect in court if no case has been instituted. Now, that understanding is in conflict with Justices J. Lecit, R.V. Wendell, and M.J.A. Emukule. Ladies and gentlemen, mine is not to be seen to be pigeonholing this problem casually. And I'm not trying to pigeonhole these judges casually at all. No. We are just discussing what we can see. We don't have to be politically correct for us to discuss what concerns us. The three judges say that we think an application must first be made under section 88(1) of the Criminal Procedure Code for the magistrate trying the case to grant or refuse to grant permission to the plaintiff to conduct private prosecution. Now, section 88 does not talk of an application. Let me repeat that. Section 88 does not talk of an application. It is the three judges who, in this case, are imagining law. Imagining law. The three judges use the word trying, which Justice Simpson and Sachdeva have given meaning to mean that there's a suspect in court. You cannot have a suspect in court if a case has not been instituted. The three judges continue. It is after permission has been granted for the private prosecution to be conducted that section 89 and section 90 of the Criminal Procedure Code can be brought into effect and criminal proceedings instituted. Now, ladies and gentlemen, this is incredible. This is incredible. And I would say this is the real monument to the memory of the three judges, that they have misunderstood trying. It is incredible because you'd expect that when you bring in three people together, they do not take the level of the person most intellectually challenged. There should be some kind of synthesis so that you bring out the best intellect. So the three judges are trying a case that has not been instituted. The three judges are trying a case that has not been instituted. So, as per the understanding by the three judges, you arrest a person without a warrant, say an OCS for defilement, and one, you take the restrained person with you to a magistrate and file an application for permission under section 88(1) for the Criminal Procedure Code. 2, you prosecute the application for permission with the suspect by your side. 3, you then take the suspect before the magistrate for the complaint, the recording of the complaint, and the drawing of formal charges under section 89 of the Criminal Procedure Code. 4, go back to the magistrate and apply for permission to conduct that trail under section 881 of the Criminal Procedure Code. 5, you'll end up applying for permission twice. First, for permission to make a complaint, and second, for permission to conduct trial. Note that the Criminal Procedure Code does not require the person be brought before a magistrate to be brought by a police officer. The public is free to arrest suspects. Now, Justices Simpson and Sachdeva and Justices Lesit, Wendo, and Emukule have different understandings of section 881 of the Criminal Procedure Code versus section 89 of the Criminal Procedure Code. It is for that reason that I want to identify with Justices Simpson and Sachdeva in the understanding of the place of section 88 in the justice chain. And it is for that reason that I score Justices Simpson and Sachdeva 1 and Justices Lesit, Wendo, and Emukule 0. For the same reason, I find that the 3 judges, their grave misunderstanding of section 89 of the Criminal Procedure Code, which says proceedings may be instituted either by the making of a complaint or by the bringing before a magistrate of a person who has been arrested without a warrant. So, for them, you need to have acquired some permission before you do that. You cannot institute proceedings before you have permission, before you have applied and got permission. So the 3 judges shift institution of proceedings from section 89 to section 88 of the Criminal Procedure Code. They attempt to qualify section 89 a law written by certainly smarter people. For that reason, I want to score the Criminal Procedure Code 1, the 3 judges, nil. Section 89, subsection 3 of the Criminal Procedure Code says a complaint may be made orally or in writing, but if made orally, shall be reduced to writing by the magistrate, and in either case shall be signed by the complainant and the magistrate. Obviously, we cannot roll out section 88 before the magistrate has done the clerical work. And perhaps the mammoth egos that live in the institution of our courts cannot imagine doing that. That is the law, however. For that reason, Criminal Procedure Code section 89.3.1, the 3 judges, receipt, Wendo, and Emukule 0. The Criminal Procedure Code section 89, subsection 4 says the magistrate, upon receiving a complaint or where an accused person has been arrested without a warrant is brought before him, shall, subject to the provisions of subsection 5, draw up or cause to be drawn up, and shall sign a formal charge containing statements of the offense with which the accused is charged, unless the charge is signed and presented by a police officer. No magistrate can be said to be trying anything under section 88.1 unless a formal charge is available. The charge can only be processed in section 89. Let me repeat that. No magistrate can be said to be trying anything under Section 88(1) unless a formal charge is available. The charge can only be processed in Section 89. For that reason, I score Criminal Procedure Code Section 89, subsection 4(1), and the 3 judges, Justice Lesit, Wendo, and Emukule, 0. Criminal Procedure Code Section 89, subsection 5 says, where the magistrate is of the opinion that a complaint or formal charge made or presented under this section does not disclose an offense, the magistrate shall make an order refusing to admit the complaint or formal charge and shall record his reason for the order. This is a very beautiful section. We don't want to flood the courts with complaints that are non-complaints. So this is the section that is permitting the complaint. So for the purpose of making a complaint, this is the section that gives the permission. And for that reason, rather than put a logjam in the justice system, the magistrate decides to strike out the complaint. Now the 3 judges should note this, that you don't need permission to institute proceedings against a suspect. And there is no way you can roll out Section 89 after Section 88. So, as for the 3 judges, we could say about them, let's say this, before a magistrate has considered the complaint under Section 89(5), it is pointless to involve the suspect in the court process. Let me repeat that. Before a magistrate has considered the complaint under Section 89(5), it is pointless to involve the suspect in the court process. To judges Lesit, Wendo, and Emukule, the first port of call is Section 88 of the Criminal Procedure Code. Once again, we say this is incredible and it's shameful. It's for that reason that I want to score the Criminal Procedure Code Section 89, subsection 5(1), Justice Lesit, Wendo, and Emukule, 0. Justice James Wakiaga identifies with the position of the 3 judges. Justice James Wakiaga puts the institution of proceedings under Section 88 of the Criminal Procedure Code by allowing himself to be totally misguided by Judges Lesit, Wendo, and Emukule. For that reason, I want to score the Criminal Procedure Code Section 89, 10, and Justice James Wakiaga, 0. Ladies and gentlemen, the Criminal Procedure Code Section 88 is titled Permission to Conduct Prosecution. Subsection 1 says a magistrate trying a case may permit the prosecution to be conducted by any person, but no person other than a public prosecutor or other officer generally or specially authorized by the Director of Public Prosecutions in this behalf shall be entitled to do so without permission. I want to repeat that bit. Shall be entitled to do so without permission. Note this section, it does not talk of an application at all. Now, Justice Mkule, they say that such a person must apply for permission or leave. The three judges, they understand that under Section 88, subsection 1, one should apply for permission. But the section itself does not say that. The section does not require one to apply for permission. The three judges go ahead and equate applying for permission to be equal to leave, and that is correct. That is correct. Permission you have to apply for is leave. Permission you have to apply for is leave. And there is no way the law can use permission interchangeably with leave. No, it can't happen like that. There is a clear distinction. There is a clear technical distinction between to allow, to let, to permit, and to grant leave. They go ahead and say, we think that in the case of a private prosecution, an application must first be made under Section 81 of the Criminal Procedure Code for the magistrate trying the case to grant or refuse to grant permission to the plaintiff to conduct private prosecutions. Now, permission, they go ahead and say permission must be sought for and obtained from a subordinate court before the institution of private prosecution. Isn't that? Permission must be sought for and obtained from a subordinate court before the institution of private prosecutions under Section 88(1) of the Criminal Procedure Code. Ladies and gentlemen, these are three judges. They are saying that permission must be sought for and obtained from a subordinate court before institution of the private prosecution under Section 88(1) of the Criminal Procedure Code. The three judges have neatly put institution of proceedings under Section 88(1). And they have interpreted the statement shall not be entitled to do so without permission to mean that the person wishing to conduct prosecution must apply for permission. They go ahead and say, we think that in order to avoid the confusion that seems to have attended applications of this nature, we recommend that in order to have some proper procedure, that a private prosecution in criminal proceedings should be commenced first by an application before a subordinate court under Section 88(1) of the Criminal Procedure Code for permission to grant private prosecution. That application should be heard first and determined. If the plaintiff has exhausted those channels and to his dismay, neither the police nor the Attorney General take up his complaint, she is legally entitled to seek permission. Legally entitled to seek permission, which means that I cannot straight away attempt to institute proceedings against suspects unless I have gone through the police or the Attorney General. Now, let us agree on this, that the law does not talk of one having to apply for permission. Permission you have to apply for is leave. The law does not talk of leave. There is a technical difference between to allow, to let, permit, and to grant leave. For that reason, I want to grant the Criminal Procedure Code, Section 88:10, and the 3 judges, Receipt, Wendell, and Mukule 0. Ladies and gentlemen, my understanding of the word permit as used in Section 88 of the Criminal Procedure Code is analogous with a security officer standing outside a church just before the church service. It is known, it's assumed that everybody who turns up at that gate before the service wants to go in the church to worship. However, that security man has a duty, an obligation, and even powers to stop some people and search them. If he finds something suspect, something that could hurt the public, that security officer is free. Actually, he is required to stop that person, even raise the alarm, and arrest the person and restrain the person, because that person is a danger to the public. However, on average, everybody who turns up at that gate is assumed to be attending the church service. We can have similar analogies with school. Even supermarkets, it's assumed that the person who is turning up at the door of the supermarket, he wants to come to the shop, for example, or even buy some items. That does not stop the security man from searching the persons who turn up there for security purposes. So, people who are turning up at the gate, they don't need to apply to get inside. But the gate man is there. The gate man is there just in case there are people who want to abuse that institution. That is the way I understand Section 88 and the word permit that is there. The complainant, the person who wants to prosecute a crime, is automatically granted permission unless the magistrate has reason to believe that this person is abusing the court process, or there's a conspiracy between the prosecutor in court and the suspect. So I accept that the magistrate has the power to stop an intended prosecutor. But the default understanding is that everybody is allowed. Everybody is permitted unless otherwise. The default understanding is that everybody is permitted unless otherwise. Not to mention that any other understanding will be in conflict with our Constitution 2010, which gives us a right to a fair trial. Thank you.